Good to be here. Jeff Gore with the law firm of Hefty Wiley and Gore. We serve as general legal counsel to Riverside Regional Jail Authority. Talking with your finance director, Mr. Harris, who's a member of the board of Riverside, as you know, it sounded like you all were interested in an update particularly on the recent settlement agreement that was reached with the Board of Local and Regional Jails. So that's what I plan on addressing. If you have any questions about other things or about that agreement as I walk through it, please stop me. Happy to answer questions. And I'll be as brief as I can, but I'll also go into more detail if you wish. And certainly can follow up with more information at any time with Mr. Casey or you all directly. So,
very good. Very good.
Does that sound right? Does that sound
That's
okay?
right. Good. I'm glad you mentioned we can ask questions during your
Absolutely.
presentation versus after your presentation, for being clear on that. Thank you.
Mr. Chair, any time, just stop me. So I'll just give a little background. You're probably aware of most of it, but just for the benefit of the audience as well. Back in April of this year, the board, actually a committee, the Jail Review Committee of the Board of Local and Regional Jails, made a recommendation to the full board that Riverside be decertified based on its preliminary findings from an investigation of 3 inmate deaths in custody. The deaths were one was from 2019 and early 2020, the others. So that came at the conclusion of that investigation. In April, the committee met, came out of a closed session, made that recommendation based on preliminary findings. That set in motion a process under I'll just call them the board. It's a mouthful to say the full name. Under the board's procedures, there's a process that's triggered at that point whereby the jail authority had the opportunity to file, to review the information, which we were provided based on the 3 cases in the investigation, and to file objections if the authority had any objections to the preliminary findings. So that's one thing it triggered. It also triggered the ability, under the board's rules, for the jail authority to begin discussions essentially with the executive director of the board to try to find a way forward short of essentially litigating it and going through an appeals process. So sort of parallel tracks, and that's what the authority did. On June 4th, we filed notice of objections to the preliminary findings and recommendations, and so that was June 4th. I'm sorry, and that was the deadline under the board's procedures to file that. In the process of doing that, we worked with medical experts in correctional health care that do this for provide these services for many other facilities, since most of the preliminary findings were based on medical care, allegations regarding medical care. As you know, Riverside contracts out medical care to a vendor that provides all of the care. So it provides the staffing from the nurses to the mental health professionals to the doctors to the psychiatrists, everyone provided by the contract vendor. That's fairly common with large facilities. The medical care that's provided in jails across the state, the model varies. Everyone does it a different way. So that's one model, and that's what Riverside has traditionally used, basically the turnkey contractor model. So most of the allegations were based on medical care. So we worked with outside correctional healthcare experts to review the case files, to review the medical files, and that provided us input on the objections that we filed. So that was done on June 4th, and that's what really then triggered the discussions in earnest with the state on is there a way to keep the facility open to address the concerns of the Jail Review Committee, the recommendation being to decertify and essentially closing the facility to send the inmates back to the jurisdictions of origin. So that was the recommendation. So we filed our objections. then we began in earnest discussions that really ran from May through early September. This is a new process. The state's never done this. The Board of Local and Regional Jails was just empowered with or directed to investigate inmate in custody deaths in 2018, and really they didn't start doing it until 2019. And this was the first case of a recommendation for decertification and the first case of a negotiation related to that. So they were sort of breaking new ground as we were, both hoping ultimately to find a resolution that worked for the state, for the jail authority, and the 7-member jurisdictions that would not result in closing the facility. So that's what we worked on. Again, it took about 5 months. In September, we reached an agreement, and that's what I'm here today to walk through. September 23rd is when the state board approved the agreement. The following day, the Riverside board met and approved the agreement. So I'm going to hit the major terms and conditions. This is a public document. You may already have, I think you may already have a copy. Certainly the public can have a copy if they request it. We have it, the state has it, the press has it, so it's out there. But some of the terms might require a little bit of explaining, so I'll just walk through it. Stop me again if you have any questions. So first of all, there were 5 state regulations that were allegedly violated in one or more of these 3 cases. The first one has to do with requiring 24 access to emergency medical and mental health care. The second one has to do with the medical screening that is required to take place upon intake of an inmate to the facility, making sure that's done according to regulations and state standards. The third one has to do with informing inmates upon arrival at the facility of their rights to access medical care and logistically how they do it. The fourth one has to do with classification of inmates. That's sort of a corrections term of art, but classification is where do you put an inmate in the facility based on factors related to their sentence, to their, it could be escape history, assaultive behavior history, medical needs. It's understanding the needs of that inmate, any risks of that inmate being with certain population, and properly classifying where they go. That was the fourth one. The fifth one, and the fifth one is the main one that really was a little less medically related, and that was the state requirement that security inspections, so rounds, you might look at them as seeing every inmate in every cell or pod, take place twice per hour at random intervals. So those were the 5 regulations under state law that the State Board's Jail Review Committee found through their preliminary investigation and findings were violated. So what the agreement does, it establishes some new requirements for the facility that are aimed at resolving concerns on all 5 of those standards. And I'm going to walk through those now. Well, first preliminarily, what does the agreement do? It resolves those 3 investigations, so it essentially closes those cases. It also avoids decertification and closure. And finally, sort of broadly, it terminates and supplants the 2019 probation order. I'm sure you're all aware, in 2019, which was, I believe, the first or one of the first instances of the board exercising its new authority to investigate in custody inmate deaths. There were a series of sanctions issued to jails around the state in 2019. That's when Riverside was put under a 3-year probationary certification. So we're 2 years into that when we're having these discussions with the state. So what this agreement does is it sort of closes the book on that, which makes sense because this agreement is much more detailed. There were no details in the probation status from 2019. It was simply, you're on probation, we're gonna come do inspections unannounced, and you're gonna provide quarterly reports. That was the extent of it. It was a one-page order, whereas this is a 20-page detailed agreement.
Mr. Gore, can I
Yes, ma'am.
interrupt and just ask a question here?
Sure.
So the first statement you made, though, it closes the 3 open cases, meaning that there's going to be no further investigation of those. Is that what that means? That basically, we're moving forward from this date when the order is signed by both sides to move forward with this new 20-page agreement as to how we will proceed forward, correct?
That's right. It resolves those matters. So they are no longer pending investigations. And again, to my knowledge, well, I think it's pretty clear, this is the first one of these agreements. So that's
So it
what it does.
resolves those matters as far
Correct.
as the investigation goes. It doesn't necessarily resolve any potential legal challenges that exist regarding those matters from family members or.
Oh, absolutely. It has no effect on third-party civil claims. Absolutely. That's a good point to clarify. And
Right, for those of us as lawyers, we kind of get
Yeah.
that, but just for the general population and
Correct.
even our colleagues here, I think it's important to understand that from that perspective, there still may be some litigation or other issues that ensue as a result
Sure.
of those.
Sure, potentially, yes. It sort of closes the book on the regulatory enforcement, not on any third-party civil claims that could arise. To date, no suits have been filed in any of these. That doesn't mean they can't. I think the statute of limitations may have passed on one or more of them, which I think is telling as to the merits of the case. But we're not going to go into the details, I don't think, today of the case.
And Mr. Chairman, if I may, and just to tack on to Ms. Haley's question, the elimination of those 3 investigations would then also eliminate any potential evidence that could be found in terms of wrongdoing by the regulatory scheme. Is that correct? In terms of any potential cases moving forward?
Moving forward, like future?
Sure. In other words, a future civil case could not rely or use any of these investigatory materials because they won't exist.
Well, they're public records. I mean, and they could be subpoenaed, I suppose, in civil litigation. Certainly all the jail's medical records would be subpoenaed in any civil case. So that's all there. And so whether or not this agreement would have any bearing on a civil case, I can't say. I think it's sort of new ground in Virginia.
And just to clarify, the jail is still on probation, is that right?
No, that's not correct. So
It's off of probation
yes.
entirely right
So
now.
So this agreement entirely replaced the 2019. There was 1 year left on that, less than 1 year, because we're going to go through June of 22. So that is by agreeing to this consent agreement, the state essentially extinguished that probationary order.
Does that mean that those random inspections no longer take place down there?
Well, I'll get to that. So,
Okay, I won't jump the shark.
And
Go ahead.
it'll make sense when I go through it, Mr. Winslow, because the new agreement is much more prescriptive. I mean, you'll see when I start walking through it. It's pretty detailed.
Are there still 2 more deaths that haven't been included in those 3 to be investigated and that could change or affect what you're sharing with us today?
There have been deaths that have occurred since early 2020. Yeah. Now, how those impact this agreement, I'll get to that.
Mr. Chair, one last question. So the agreement closes the investigations, is that correct?
Yes, sir.
But those investigations have been thoroughly investigated, right?
I would argue that they were not thorough investigations, but they have been completed, yes.
Well, that's not good. 'Cause
Well, they've been investigated by the jail. I would argue that the state's process wasn't thorough. But yes, they were fully investigated by the state investigator who provided a report to the State Jail Review Committee, which was the basis of the recommendations of decertification. That's accurate.
Okay, so the investigation was conducted.
Yes.
Information was passed forward to the state.
Correct.
Which is why they, in your own words earlier, moved to decertify the jail in the first place.
That's right. That's why the recommendations were based on the jail's, the state employee, the employee of the jail board's investigation.
I I think it's important to clarify to the community that the investigations were completed and it's
Sure.
not just being closed out without some type of investigation having been
Correct.
concluded.
Correct. No, I didn't mean it from that standpoint. No, the investigation was completed per the State Board of Local and Regional Jails policy. Their investigator at the time did his investigation. The jail at the time provided every record that was ever requested, including all medical, I mean, on and on and on. There was the authority, like regional jail should, it was an open book in these investigations. So there's nothing that shouldn't have been known about the cases. So I think from that standpoint, yes, they've been fully
But
investigated.
make sure that the impression we weren't giving the community is that, that a complete investigation had not been conducted and that we're just shutting them down because they come into a new agreement.
Right, no, that's not the case. And I think part of I think once the jail authority was able to respond for the first time to the recommendations, I think the jail authority provided information to the state that helped us in reaching a settlement. In other words, provided some clarity to the cases with more information. Yes, sir. So now I'm going to go through the substantive provisions, and you'll see they're pretty prescriptive and I think positive, and I think well, I'll let them speak for themselves, and you all can draw your conclusions. And I'm certainly able to provide any opinion you may want to hear from me after we walk through it as to the impact of these standards. So the agreement establishes 3 internal audit procedures that Riverside and its healthcare provider are required to conduct. The first one is, I'll go through each one. One is a Riverside audit, one's the health provider, and one is a joint audit. So these are daily and weekly and monthly reviews that have to take place by the jail, by the healthcare provider, and joint discussions by both of them. And the first thing that this provision of the agreement required was that the jail create a new position. This is a new position, as far as I'm aware, in Virginia in any jail, and that's a standards compliance officer of a command level rank, which has happened. There's someone in that position currently. And that officer, their main focus is ensuring that all state standards are complied with. That's their job, right? They may have some other duties, but that's the emphasis of that position. And that involves daily reviews that are related to the 5 standards I mentioned earlier. Making sure the screenings are done on intake properly. Making sure that the rounds or security checks are made. Ensuring that inmates are provided with the information they need to access health care. Ensuring that all those standards are met. The classification, very important, ensuring that that is done. So on a daily basis, the SCO, Standard Compliance Officer, is going to all those parts of the facility, meeting with all the supervisors, all the line staff, or at least the supervisors and probably some line staff as needed, to see the reports, to interview people, to make sure all these standards are complied with. And writing that up every day, every week, every month. If the standards compliance officer comes across a lapse, a potential or actual violation of any of these standards, it's a she currently in this position, she must immediately report that to the superintendent or assistant superintendent. They then immediately go to that part of the facility and find out what happened and require corrective action to be implemented. All this is written up in weekly reports that are rolled up every month to a monthly report. That monthly report is going to go to the state board at the end of each month. So it's going to include, everything the SCO did that month, any problems she finds, how those problems were cured or remedied. That's new, obviously.
So what?
That's new. That's
new?
a
Okay.
new stand. I mean, no facility is doing that. And I think, again, and I think that's positive. It's accountability, and it creates accountability on down through the staff, all the way up to the command level and the superintendent. And we're working on the first monthly report now, under the agreement. And so I know that the first one is in progress and will be filed shortly. That's the internal jail staff audit. Then there's the healthcare provider required audit, with the focus really on medical care. This requires the jail's healthcare provider to create a continuous quality improvement program, QCI, which is actually a sort of a best practice in the industry. Horizon Healthcare is the vendor, the current provider, and they are doing this, and they're required now under this agreement to do this. They're not a party to the agreement, but the authority is, and if the authority's provider doesn't do it, then there's a problem. So this involves routine review of all aspects of screening and health care of inmates, and checklists and weekly meetings and documentation, and identifying any problems with how any case was handled, creating a corrective plan on how to avoid that in the future. So it's pretty prescriptive on what this continuous quality improvement program requires. The third internal audit.
Is that, I'm sorry.
Yeah.
Is that a new and different vendor than, for medical?
It is.
Provisions than existed before?
It is. So it was a different vendor that was in place at the time of the 3 cases that we're talking about. And shortly thereafter, the authority, under the new superintendent's guidance, moved forward with a different vendor. There were issues with that contract and that contractor, and so, yeah, there is a new provider that was.
Thanks for clarifying. I appreciate that.
Yeah.
My question,
And-
audit by whom? I
Yeah.
want to make sure that we
So,
don't
yeah.
avoid or repeat unacceptable behavior we've heard about before.
Right. So it is a new provider, and I'll speak a little bit to that in a minute. And then the third one is a minimum monthly, but I think it's weekly, actually, as a practical matter, joint meeting between senior level jail staff and the medical provider. This is the Medical Administrative Committee, or the MAC. The MAC is charged with reviewing all high-risk patients, all the statistical data regarding inmate health care and their process for providing it, and any needed corrective actions. In other words, this is really to foster communication between jail staff and medical staff to ensure that nothing gets missed. And that produces a report as well. That report will also be provided to the state board on a monthly basis. So 2 reports on a monthly basis. One is from the jail SCO, Standards Compliance Officer, internal audits, and one is from the QCI process through the medical provider and the joint MAC, Medical Administrative Committee. So those 2 reports are going to be going every month for the next 2 years to the state. So those are new processes that are in place and required and are now operational. The agreement also requires that all policies and procedures comply with the 5 standards I mentioned earlier. So part of this process was to make sure that all the policies were up to date and complied with state standards. So the exhibits to the agreement are a binder like this, because it's all the standard operating procedures and other related policies to these standards. And the board determined by accepting the agreement that the standards were up to date. And it's one thing to have the policies in place, it's another thing to have the actual practice day-to-day. So the agreement deals with both practice and policy. Now, on top of those 3 internal audits, there is an additional section in the agreement that deals with, just throughout the facility, any issues that are identified by anyone at the facility.
Would this be, Mr. Chairman, would this be like the window being broken and drugs being thrown into the jail, that sort of a situation?
Those standard, I mean, that was not one of the alleged standards at issue here. I can address that later. That has been addressed, but that's not part of this agreement. No, it's, again, this is all focused on those 5 standards. Again, essentially healthcare related. Healthcare, mental health care, screening, and security rounds. That's really the focus of the agreement. So there's a section on sort of an internal daily process of addressing any problems right away. So not waiting for the weekly report or the monthly report, but if things are caught any day, they go to the superintendent or assistant superintendent. Corrective action as soon as practicable has to happen, has to be documented, and that's in there as well. Any employee discipline that results from any incident like that would also have to be documented and reported and provided to the state. So there's really 4, I mean, in addition to the 3 internal audit processes, there's also this sort of a daily procedure that's put in place on how things have to be handled if there's any potential violations that are flagged by any employee, and corrective action must be taken right away and documented. So those are really the main sort of substance of sort of new procedures that have to be in place and have to be abided by. There's some other things that the agreement does. And one thing gets to questions you've asked recently. The board did recognize things that the jail authority has done in the last year or so that I think influenced their willingness to reach a settlement agreement, including changing its healthcare provider. There were issues with the prior one, and that when they changed after these incidents, they changed healthcare provider, mental health provider, and I think things have been on a much better footing. Evidence of that is the Riverside has obtained certification from the National Commission on Correctional Healthcare, which is an accreditation, one of the top, along with the ACA, is one of the top accreditation agencies. This one focuses on inmate healthcare and mental health care, and not a lot of jails around the state have that accreditation. I think that's a testament to the staff and to the new provider and changes they've implemented. So that's acknowledged, that's in the agreement, and the state acknowledges that that's positive. Regarding security rounds, ensuring that those are always made, the daily inspections every 2 hours at random intervals. The jail has installed, and I think it's now operational, a new electronic system that will create electronic records and will automatically note if rounds are made or missed.
Don't they have separate desks that are certain distance apart that need to be filled for the proper security to take place in there? Has that been addressed in this? Because I understand a lot of times there's not enough officers to fill those desks, and that's a key portion of the security plan for the jail. Is that addressed in here?
So it is, to some extent. So I'm getting to that. It's a good question. The agreement also recognizes, to your point, Mr. Engel, that the jail authority in the last 2 budget cycles has invested in increased pay for entry-level staff and raises for all staff, significant raises, and that has helped recruitment and retention. And there were a high number of vacancies going back a year or so, and I think over the past year, since the actions that the authority board has taken to budget resources to increase pay across the board and starting pay has had a significant effect already, and decreasing vacancies. So that's the extent the agreement addresses that issue. There's no sort of.
In essence, he's talking about staffing, which is one of the major egregious issues we found when we heard about this some months ago.
Sure.
It was just egregious in terms of things we heard. It was medical, it was even legal, teams unable to meet with their clients. That was also unacceptable. But go ahead and finish, and then we'll wrap up.
Right. So I think the
Comments,
staffing.
additional questions and
Sure,
comments.
absolutely, Mr. Chair. So the vacancies are way down. I mean, they're down in the teens or 20s, where it was 3 or 4 times that a year ago this time. So I think the trend is positive, and I think the state recognized that on the staffing issue. The agreement also recognizes that the authority has had successful audits, state and federal audits, over the last couple years, and that's a positive trend as well. So,
Do you mean financial audits or medical
well, yes,
audits?
financial audits, but I'm talking about correctional audits.
Correctional audits?
Yeah.
Okay.
So the authority, Riverside houses federal inmates for Federal Bureau of Prisons, so that involves periodic audits from the BOP, and those have all been successful, and the authority continues to house inmates for BOP, as well as the unannounced audit inspections that took place under the former probation order. There have been several of those, and the authority has passed those as well. So the jail has. So that was recognized as a positive trend in the agreement. And I think this is one of the most, so that I've sort of gotten through the main substance. Now the main enforcement. So what happens if Riverside self-reports, or if an unannounced inspection, which the board can do, they can do unannounced inspections under this agreement. What if they find a violation? What the agreement puts in place is a process for, if that happens, and the state board feels that there's been a problem, a potential violation of any of these standards, instead of going straight to an investigation and enforcement action, it will involve some discussion between the state and the jail superintendent to try to figure out, okay, get all the facts, what really happened here, and what can Riverside do to fix it if after that discussion there still appears to have been a problem. In other words, a mechanism to try to resolve the matter and make sure it's corrected going forward versus going right to an enforcement action, which is how this one happened. And interestingly, the state board has recently adopted a policy modeled on this that essentially will apply to all their inmate death investigations statewide. Prior to that, there was no real mechanism for those discussions. It was more of a one-sided investigation without a lot of dialogue, and I think that's a positive. I mean, everyone's goal is to have a safe run facility. It's not to Monday morning quarterback and impose sanctions. It's to make sure things are done right. And I think this agreement, and I think this provision as well, gets us towards that shared goal with the state. Of course, if through that process the state's not satisfied, they can proceed with enforcement action, further investigation of any incident at their discretion. But the agreement requires that they first sit down with the jail staff and try to figure out exactly what happened and if it's already been fixed or if it can be fixed. So the agreement has a 2-year term. At any time after 1 year, Riverside can file a request to the state board for an early termination. If everything has gone great and the state's concerns are resolved, and every unannounced inspection goes well, the scenario could be that Riverside applies to be out from underneath this agreement a year early. Doesn't have to, but has that option, and then it's up to the board to decide whether or not they want to grant that early out on the agreement. So otherwise it's a 2-year term. Even at the end of 2 years, if the state feels that Riverside has had repeated violations and it has not made good faith or successful efforts to remedy those violations, the agreement can continue sort of indefinitely based on what the state board thinks. Obviously, we hope that's not the case, but the board sort of insisted on them having that authority should things not be on the track that they hope they are.
You said that the facility's no longer on probation. It's no longer under the 2019 probation
Correct.
agreement, but this agreement is still a probation period, is it not? I mean, it's 2 years where you're being looked at
Yeah.
for violations and to make sure that there is compliance. So isn't that still, I mean, is it the super secret probation? I mean,
It's a legal agreement, it's a consent order, similar to what DOJ does with facilities at the federal level. And, I mean, maybe it's semantics. I feel like it's not, because I feel like it's substantively different, because the probation was very unclear. And it simply said, you've got to do this. We, the state, can come in and do inspections. If we're not satisfied, we can impose further sanctions. There was no detail to it. So I think it's important that this does supplant that, because this is very detailed, and I think both sides have a better understanding of what the expectations are.
I don't disagree with that, but I would say that this agreement still amounts to, or is equivalent to probation.
Mr. Chairman?
Well, I think we get into semantics when we talk about that, just to say overall. But what we want to do is we want to make sure that, and I want to hear from the sheriff as well, who has intimate knowledge in this briefly, as you wrap
course.
up your discussion here in terms of the audit procedures. This agreement is effective September 23rd, as I understand it was signed and approved by all parties.
24th was when the authority
24th was the
executed it.
date of the agreement.
Correct.
And of course, to your knowledge, have the 3 internal audit procedures been performed since the ratification of this agreement?
To my knowledge, that is an ongoing process. It's been happening, and the standards compliance officer has been in place since around the date of this agreement. So I don't know the exact day that person filled that position, but yeah, this is
Okay,
this is
thank you.
happening, and they're about to file. The jail's about to file, I think, its first monthly
Okay.
report.
Thank you.
Yes, sir.
Other comments as you wrap up?
Okay, sure. And the only other, I think those are the main points. I mean, the other thing, there's a confidentiality provision, because, we're dealing often with sensitive medical information of individuals, and so there's a sort of a provision related to that. So that's the agreement. I'm happy to
Okay.
yield to the sheriff
Thank
or
you.
answer questions.
Yeah, we're looking for, too, accountability.
Yes, sir.
The deaths are just not normal, and we should not perceive it as being something we just blasé, pass on and pass by, but rather accountability is the order of the day, I think, for all institutions, and certainly this one, given the egregious practices we heard about just a few months ago. And I'm going to ask the sheriff, and you certainly feel free to ask questions, board members, but I want to ask the sheriff his knowledge relative to where we are versus where we were when we even agreed as a board to write a letter, I think, to the public safety secretary in regards to this case. Sheriff, would you like to make a comment relative to this, as we tend to focus on this discussion?
Mr. Chair, member of the board, Dr. Casey, I'm just going to give a big overview of where we are today with Chesterfield County inmates, because that's what's a concern to myself and I believe all of you. Our overall population today is under 800, and that's probably the first time we've seen that in many years. And that's not really related to COVID. We've seen a decrease over probably the last 8 years of new accessions into our jail have steadily gone down over the years. So we're under 800 total today between all the facilities. Today, we do have 358 at our jail here in Chesterfield County, 414 at Riverside. We have 30 at Pamunkey, and we have 6 at Southside Regional Jail. We do have an MOU with another jail that was supposed to take 100 of our inmates. They're dealing with COVID issues there and their own medical staff issues, so that's been put on hold. Of all those inmates, we are down to 96 total that are out of compliant. The state has done a good job recently of picking up people that were out of compliant and state-responsible inmates. We still have 96 Chesterfield inmates who do fall underneath that, though, today. As we continue to see our population go down, we do have a new legislation that comes into effect July 1st. That's the new good time credit law that was voted on last special session with an effective date of July 1st, 2022, which essentially converts good time credit from 4.5 days for every 30 served to 15 days for every 30 served, made retroactive to forever. So if you've been in a prison for 40 years, DOC now has to go back 40 years to your first day of incarceration and start recalculating all your time at that new rate, 15 versus 4.5, for a certain host of crimes, not all crimes, certainly. We're also looking at that. We believe that will reduce our population between all the facilities by 200, taking our overall population down to probably around 550, somewhere around there, come the end of 2022 as we navigate through this new law. So that's where we are today with our overall picture, and I'll take any questions you may have.
Any questions, board members, or comments?
Sheriff, in relation to the previous report, correct me if I'm wrong, but the understanding was that the reason the jail was recommended for closure is because the state determined that they were responsible for the three deaths because of their negligence. Is that accurate, or am I wrong?
Right, that was the state's determination. They referred to them as jail responsible deaths, that there was some part of the jail for contributing to the death, yes.
And to your knowledge, since under this new agreement, has the state reclassified those, or is it still classified the
No,
same?
I don't believe they have reclassified them. I just think they said, okay, those investigations are done. We're moving forward under these conditions under the consent decree.
Okay, thank you.
Other questions, comments?
Mr. Chair, just one question. I know one of the issues that we had talked about before in the past, Sheriff, and if it's appropriate, we can ask somebody else this question, but was the overall combined funding of the facility that led to just another level of concerns when it came to having appropriate staffing. And so what we're hearing is that, you know, that the jails move forward in addressing staffing issues by increasing pay, by making the staffing more attractive, by adding these additional positions that are required pursuant to this agreement. How do we look on funding? Where does that leave us on funding for the
Right,
for this
and I don't want to speak for Mr. Harris, but I'll take this liberty. There is a committee, the finance committee that he's on, is getting together to look at the recent evaluation that was done by an independent contractor, to look at the recommendations there and come up with what we think the budget should be. I will say for the last several years, year after year, Chesterfield has come to the table and asked for a higher per diem because we believe the per diem needs to be higher to meet the needs. Mr. Gore, when you say the vacancies are filled, I believe the vacancies we've had in operations have been filled, but there's still, I think, vacancies frozen for the purpose of balancing the budget.
Yeah, maybe Mr. Harris can speak to that.
I apologize, Mr. Harris, because I know this wasn't a presentation, but even generally, if you can help us.
Yeah, I think generally I think Mr. Gore's comments are spot on in terms of measures that the authority board took to try to first stabilize the staffing that was already in place. And, you know, I think by all accounts, they've made some good inroads there. I think Sheriff Leonard's commentary is also correct. As with any organization, they do have a number of positions that they go in that are sort of unfunded on day one, with some assumption there's going to be some normal rate of turnover. That rate's probably higher than we would like it to see as Chesterfield, as the authority board itself. But we are, you know, for the first time in my experience with the authority, getting together the finance side of the board, those 7 individuals with that perspective in life to really take a hard look at a lot of these questions, and including some potentially deferred maintenance issues with the facility itself, which we haven't really, you know, had the chance to delve into. So I'm very encouraged by, you know, all 7 members' willingness to come to the table and have those discussions. Again, just something that we haven't done. We did have the outside entity take a look at the facility itself, unrelated to what Mr. Gore just walked you through, and they provided us a comprehensive staffing model that we've never had before. So basically, we have a template, if you will, based on, you know, the number of inmates there, the types of inmates we can go through and sort of plug and play with that and come up really with an ideal staffing matrix and take that back to the full board. And so that's got support of all the members. So I think, you know, in terms of the financial end of it, you know, we've certainly, I think, probably turned a bit of a corner, and, you know, we're going to have conversations, at least this heading before budget season, long before budget season, that will hopefully set us up for a, you know, I don't think you're going to see it get done from a financial perspective all in 1 year. But what we haven't had, at least in my time there, is sort of a roadmap of, okay, we want to get here, and if it takes us 1, 2, 3 cycles, you know, that's okay, at least as something to plan on. So we've got a lot more tools, you know, in our toolkit than what we've had the last couple years.
Mr. Chair, and just following off of Mr. Winslow's comment, and I think going right into that discussion of financing, you know, the actual facility. So in the past, there had been not only evidence presented to us, but we've read about security issues, security in the actual facility, security with broken windows, fencing that allowed for, you know, permeation into the facility, drugs being trafficked through that. Are there provisions aside what seems to be separate from this actual agreement that we're looking at the actual facility security and the facility issues?
Yeah, I mean, it's been presented to the authority board that the fencing has been, I mean, presented to the authority board from the jail consultant that was hired by the authority to take a look at that. So that, you know, this is not as a third party going in and taking, you know, sort of a fresh look at it. It was relayed to us that the fencing has been completed, that the window repairs have been completed, but I think the, you know, spirit to the members of the authority wanted to take that a step further and make sure that we aren't, you know, as we've done here in this boardroom many times, county and schools, you know, sort of the major maintenance issues, and we're keeping up with the facility itself. Again, to me, that's a positive thing. I don't know what the answer to that question is. We can report back maybe through our own budget process here, but I'm heartened to be having those conversations. But I think a lot of the immediate repairs that have been brought to your attention have been made, as reported again by the jail consultant himself.
Thank you. Other questions, concerns?
Mr. Chairman, I just say I want to thank the sheriff for continuing his work on getting Chesterfield citizens out of the jail. I mean, I understand there's talk about whether or not what we're in now is probation. They're still on probation with me. And I think they're still on probation with the citizens of Chesterfield whose families have endured these civil rights violations for years and without anything going on. So I'm just going to say that and put a period at the end of that sentence. Only time will tell if this is going to work, this consent order, and the resources are actually going to be applied both to the facility and to the employees that are necessary to run this type of facility as we've gone over in the past, and that it's very employee intensive. So I think there are a lot of eyeballs on this, and Mr. Gore, it's an excellent presentation. I think you've pulled a rabbit out of a hat. I think you've done a very good job for your client, but concerns remain. Mr. Chairman, thank you.
I concur. Concerns remain here and will concern because we will not tolerate civil rights violations and the legal violations of clients' rights as it relates to being housed at that jail. And certainly Chesterfield has higher standards and we expect more. But I do appreciate your being here today to share the contents of this agreement, September 24th agreement, and the procedures that you outlined, the audit procedures. And hopefully a lot of this independent review of the process will be done as well versus just internal. So, Sheriff, I appreciate your view on this and continue to keep us informed so that we won't tolerate this any longer what we've heard before. So thank you, Mr. Gore, for being here.
Thank you all. I would just encourage all of you, if you have not, to tour the facility, see with your own eyes the conditions, and it's an open door anytime. I'm sure the superintendent would welcome you. So,
Well, I thank you for sharing that. In fact, I thought of that earlier to our board members. I know they have very busy schedules, but I certainly one who will take that offer up. So please make sure that I'm programmed to attend the facility in the near future.
Pass that along, and thanks for having me here. I appreciate that.
Have a great day. Thank you.